Before we jump in, I do earn a referral fee when you use the services and companies I demonstrate in the video, but there is no additional cost to you. I chose them because they're the best in the industry and you're safe with them.
Have you ever wondered about the safety of your assets and how to protect them from unforeseen circumstances? In a world where financial security is paramount, it's essential to understand the various tools and strategies at your disposal. One such tool that has garnered significant attention worldwide is the Cook Islands Trust. A favorite among entrepreneurs and business owners, Cook Islands Trusts offer an appealing solution for asset protection. But what is a Cook Islands Trust? How does it work? And more importantly, is it the right choice for you? In the complex world of finance and law, these questions can seem daunting. But fear not, for we're about to embark on a journey of understanding that will shed light on these intriguing financial structures. So sit back, relax, and let's dive into the world of asset protection. This video will guide you through what Cook Islands Trusts are, how they work, and if they are the right choice for you. Firstly, what exactly are Cook Islands Trusts? Let's dive in and unravel this intriguing concept. A trust, in the simplest terms, is a legal arrangement where one party, known as the settlor, transfers their assets to another party, the trustee, to manage for the benefit of a third party, the beneficiary. The trustee holds legal title to the property, but the beneficiary has equitable title, or the right to benefit from the property. Now, the Cook Islands, a tiny dot on the world map nestled in the South Pacific, might seem an unlikely player in the global finance landscape. Yet, it has carved a niche for itself as a leading offshore financial center. To understand why, we need to look at the Cook Islands International Trusts Act of 1984. This groundbreaking legislation allows for the creation of trusts that can protect assets from future creditors, a feature that has made the Cook Islands an attractive destination for those seeking asset protection. Setting up a Cook Islands trust is a fairly straightforward process. The settlor transfers their assets to the trust, and the trustee, who is often a licensed financial institution in the Cook Islands, manages these assets. The assets may include real estate, securities, cash, and other types of property. The main purpose of these trusts is to protect these assets from future creditors. This means that even if the settlor faces financial difficulties in the future, the assets held in the trust are generally safe from claims by creditors. It's important to note that this doesn't mean Cook Islands trusts are a tool for evading legal obligations or debts. The law is clear that transfers of assets to a trust must not be intended to defraud creditors. If a court determines that a transfer was fraudulent, it can be overturned. Cook Islands trusts offer a unique approach to asset protection, but how do they work? Stay tuned as we delve deeper into the workings of these fascinating financial instruments in the next scene. Now let's delve into the mechanics of a Cook Islands trust. Imagine you're a magician and your assets are the rabbit you want to pull out of the hat. The first step is to transfer these assets into the trust, which acts as the hat in our little metaphor. The process of transferring assets is relatively straightforward, but it's essential to remember that once the assets are in the trust, they are no longer technically yours. Instead, they're in the care of the trustee, the magician's assistant, if you will. This trustee is a crucial player in the Cook Islands trust structure. They're typically a local Cook Islands company or individual, and they are legally obligated to manage the assets in the trust for the benefit of the beneficiaries. In other words, the trustee is entrusted with the responsibility of making sure the rabbit is safe and well cared for in the hat. Now you might be wondering, why Cook Islands? What makes this jurisdiction so special? Well, the Cook Islands offers a unique blend of legal protections for trusts. For starters, the Cook Islands has strong anti-duress laws in place. This means that even if a foreign court tries to force you or the trustee to bring the assets back, these orders are not recognized in the Cook Islands. Moreover, the confidentiality laws in the Cook Islands are among the strongest globally. Information about the trust, including the identities of the settlor and beneficiaries, is kept strictly confidential. This ensures the rabbit stays hidden in the hat, away from prying eyes. One of the most appealing aspects of Cook Islands trusts is the control they offer. Even though the assets are no longer technically yours, you can still have a say in how they are managed. You can be a beneficiary of the trust, and you can also appoint an advisor who can guide the trustee on how to manage and distribute the assets. Understanding how these trusts work is crucial, but the real question is, are they safe? So, are Cook Islands trusts a safe bet for asset protection? This is the question on everyone's mind, and it's time we shed some light on it. In terms of legal stability, The Cook Islands have a strong reputation. They were the first jurisdiction to introduce asset protection trusts back in the mid-80s and have since maintained robust trust laws. These laws are specifically designed to protect assets from creditors, lawsuits, and other potential financial risks. As a result, many have found safe harbor for their wealth within these island trusts. But it's not just about the law, it's also about financial stability. The Cook Islands have a stable economy, with a strong focus on offshore banking and trust services. This economic stability, combined with their stringent regulations, make Cook Islands trusts a secure place for your assets. And what about the experiences of those who've walked this path before you? Well, many clients have reported positive experiences with Cook Islands trusts. They've praised the privacy, asset protection, and the sense of security that these trusts provide. But of course, like any financial decision, there are potential risks and limitations. For one, trust laws and regulations can change, and future amendments may impact the benefits of your trust. Additionally, while the Cook Islands have strong protections against foreign judgments, this doesn't make your assets untouchable. In extreme cases, such as criminal proceedings or fraudulent activities, the shield of the Cook Islands Trust may not hold. And let's not forget, setting up a trust in a foreign jurisdiction comes with its own complexities. You'll need to navigate international laws, potential language barriers, and deal with the logistical challenges of managing assets from afar. In conclusion, it's fair to say that Cook Islands trusts offer a high level of safety for asset protection, but they aren't without their risks. They provide a robust legal framework, financial stability, and have a proven track record. However, potential changes in laws, international complexities, and the remote possibility of assets being reached under extreme circumstances are considerations to keep in mind. While Cook Islands trusts offer many advantages, it's important to weigh these against potential drawbacks. The key is to understand your own risk tolerance, your financial goals, and to consult with a knowledgeable advisor before making any decisions. Now that we understand the safety aspect, let's talk about the pros, cons, and costs of setting up a Cook Islands trust. Firstly, the benefits. The primary advantage of a Cook Islands trust is its robust asset protection. The trust's assets are shielded from creditors, lawsuits, and even bankruptcy proceedings. This makes them a preferred choice for individuals and businesses looking to protect their wealth. Next, we have privacy. The Cook Islands has stringent privacy laws ensuring that the details of the trust and its beneficiaries remain confidential. This level of secrecy can be a significant advantage for those seeking to keep their financial affairs private. Lastly, control. Even though the trust is managed by a trustee, the settlor, that's the person who establishes the trust, retains considerable control. They can dictate the trust's terms, including how and when the assets are distributed. Now let's balance these benefits with some drawbacks. First up, the costs. Setting up a Cook Islands trust isn't cheap. You're looking at legal fees, trustee fees, and annual maintenance costs. The exact amount can vary based on complexity, but you should expect to spend several $1,000s at a minimum. Next, the complexity. Trust laws can be complicated, and the Cook Islands legal system is no exception. You'll likely need a legal expert to navigate the process, adding to the overall cost. Lastly, potential legal challenges. While Cook Islands trusts are generally well regarded, they aren't immune to legal disputes. In some cases, creditors or claimants may challenge the trust, which can lead to lengthy and costly legal battles. So what's the bottom line? Well, the costs involved in setting up and maintaining a Cook Islands trust can range from several thousand to tens of thousands of dollars, depending on the complexity of the trust and the assets involved. Remember, the best decision is an informed decision. Consider all factors before deciding if a Cook Islands trust is the right asset protection tool for you.